Chapter 6, Section 15, Campaign Finance. One of the most important requirements for running a campaign, especially for president, is money, and a lot of it. In the 2012 presidential campaign, candidates Barack Obama and Mitt Romney each spent more than $1 billion. This was the largest amount of money ever spent by two candidates, or at least it was until the 2016 election cycle, when Hillary Clinton and Donald Trump collectively spent more than $2.5 billion. In addition to the money raised by the campaigns themselves, corporations, unions, and the previously discussed interest groups raise massive sums of money in support of candidates and political initiatives. Interest groups set up political action committees, PACs, to raise campaign contributions from their members to support or oppose candidates, legislative proposals, ballot initiatives, and other policy matters. Often established to support a specific candidate or issue, PACs represent one-way interest groups can contribute to a campaign without violating restrictions on political spending. After the Supreme Court's decision in Citizens United v. Federal Elections Commission, a new type of PAC emerged, the Super PAC. Unlike regular PACs, Super PACs do not have a specific identifiable political cause. Instead, Super PACs are created to support individual candidates for office without having any direct link to that candidate's campaign. They cannot give directly to the candidates or their campaigns, but they are allowed to raise unlimited amounts of money from corporations, unions, associations, and individuals. Then, they spend the raised money to advocate for or against political candidates and issues. Federal election laws and Supreme Court cases. The 10th Amendment of the Constitution preserved for the states all powers not explicitly delegated to the federal government. This amendment provides the basis for states to control the administration of elections, including campaign finance regulation. Congress, however, also plays a major role in election administration. In 1907, Congress passed the Tillman Act to prohibit corporations from donating money to candidates running in national elections. Congress would enact various other laws to limit how much money people could give to candidates, how candidates could spend donations, and what spending information candidates must disclose to the public. Despite these efforts to control election spending, the government lacked the ability to enforce spending rules until Congress passed the Federal Election Campaign Act, FECA, in 1971. FECA provided a set of rules to regulate the reporting of campaign contributions and expenditures. FECA also outlined contribution rules for corporations and organizations to follow. FECA was amended in 1974 to place legal limits on campaign contributions and expenditures and to establish the Federal Election Commission, FEC. The FEC is an independent regulatory agency that administers and enforces election laws and federal campaign finance rules. The FEC has jurisdiction over the financing of campaigns for both Congress and the presidency. Buckley V Valeo, 1976. In Buckley v Valeo, the Supreme Court had to decide this question. Did the limits placed on election expenditures by the Federal Election Campaign Act violate the First Amendment's freedom of speech and association clauses? In this complex case, the court came to two important conclusions. First, it upheld the constitutionality of limits on individual contributions to candidates. The court concluded that FECA could restrict individual contributions in order to safeguard America's system of representative democracy. Second, the court held that governmental restrictions of independent expenditures in campaigns, the limitations on expenditures by candidates from their own personal funds, and the limitation on total campaign expenditures did violate the First Amendment. Buckley v Valeo therefore established the principle that political campaign money is considered speech. Bipartisan Campaign Reform Act of 2002. The Bipartisan Campaign Reform Act of 2002, more commonly known as the McCain-Feingold Act, tried to end the influence of soft money. Soft money is not regulated by federal campaign laws. It can be raised in unlimited amounts by political parties for party-building purposes such as voter registration and get-out-the-vote efforts. Hard money, on the other hand, is money that is limited and regulated by law. Hard money can be given to a party or candidate. This reform banned all soft money contributions to political parties, increased the limits on hard money contributions, and restricted the ability of corporations, nonprofit organizations, and labor unions to broadcast political advertisements that included a candidate's name or picture. Citizens United v. Federal Election Commission, 2010. In a previous Supreme Court case, McConnell v. Federal Election Commission, 2003, the court largely upheld the Bipartisan Campaign Reform Act. The majority opinion stated that the government's restriction on free speech was minimal and justified by an interest in preventing potential corruption threatened by large financial contributions. The results of this opinion were retried just 7 years later by the Supreme Court in Citizens United v. FEC. In Citizens United v. Federal Election Commission 2010, the Supreme Court overruled parts of McConnell v. FEC by a 5-4 vote. The court concluded that corporations, nonprofits, and labor unions have the same political speech rights as individuals under the First Amendment. This case struck down the Bipartisan Campaign Reform Act's ban on soft money, thereby allowing corporations and associations to spend unlimited amounts of money on political ads that call for the election or defeat of individual candidates.